myself, Dr. Rajesh Singh. On this webinar, I warm welcome our eminent speaker, Honorable Mr. B.N. Sri Krishnan sir, who is the former judge of the Honorable Supreme Court of India. So let me introduce about sir. So I am just presenting the PPT on this screen. Just wait for 1 minute. So about the B.N. Sri Krishnan sir. He is currently doing the arbitral and consultative legal practice since the retirement from the Supreme Court in May 2006. He started his career as an advocate at the Bombay High Court in 1962 and specialized in the field of the labor and industrial law. He was the counsel for the large number of the employees both in the public and private sector and has appeared in number of cases in the High Court and the Supreme Court of India. He was the member of the several professional associations while at the bar on being appointed as an additional judge of the Bombay High Court in 1990. He resigned from the office of the organization and he was associated with. He was made a permanent judge in 1991. His name is a synonymous with the Commission of Inquiry he headed to look into the riots that shook the Mumbai in December 1992 and January 1993. The report submitted in February 1998 has generated a wide debate in India and abroad. He has been invited by the University of California, Berkeley, Bar Ilan, Israel, and Oxford to deliver the lectures on socio-legal subjects. He was appointed as the Chief Justice of the High Court of Kerala in 2001. He was appointed as a Judge of the Supreme Court of India in 2002, which office he demitted in 2006. He was also the chairman of the 6 Central Pay Commissions. He was appointed as the chairperson of the Citizens Committee for monitoring the security issue in Mumbai by the Mumbai High Court. He was appointed by the Government of India as the chairperson of the committee for the consultation as the situation in Andhra Pradesh to consider the demand of the bifurcation of the state of Andhra Pradesh. He was also the chairperson of the financial sector of the Legislative Reforms Commission appointed by the Government of India, which gave its report in 2013. Honorable Justice Sri Krishnan also have a deep interest in the philosophy, culture, music, and education, which made him a much respected figure in all the music sabhas, religions, organization, culture, education institution, and he speaks at least 7 languages fluently. So on this platform, we warm welcome you, sir. On this platform, just a minute. Now I will tell Dr. Akhil Sayyed sir to warm welcome our speaker, Honorable former Judge Mr. B.N. Sri Krishnan sir. Akhil sir.
Thank you, Dr. Rajesh. A very good morning to one and all. On behalf of Parole Institute of Law, Faculty of Law, Parole University, and on my personal behalf, I cordially welcome Honorable Justice Sri Krishna sir, to whom we know as a chief of Sri Krishna Commission. And that is what the report we several times referred and we taught to our student, and that has been an extraordinary piece of report which for many of the judiciary officers and the inquiry commissions also has become a kind of a reference note, that if someone is there to make an inquiry, what quality and what sincerity in that inquiry has to be. Sir, ours is a private university established in 2015, and from 2016 we have started this law programs under the Faculty of Law. I am very much delighted to bring under your kind notice, sir, that we do offer 3 years LLB program, 5 years integrated program, including 1 year PG LLM program in 8 different specializations, as well as the PhD we do offer for the PhD scholars. So it's our great pleasure that your Lordship is here on our virtual platform. At the same time, I also take an opportunity to kindly invite you to be on the campus whenever the pandemic is not there. So it is my humble request and a prayer before your Lordship that please do visit our campus. It's a very good campus, and we do have good liaison with many of the judicial officers at the state level, and we would be delighted to have your Lordship to be at our campus. Thank you, sir. Thank you very much. Highly obliged.
Uh, Now, all the viewers, the topic of this webinar is judicial review and its development. So, I will just take the permission of Lordship. If Lordship will permit, then we will start our webinar.
Yes, please. Please go ahead.
Yes, sir. So, Lordship, shall I present the PPT?
Yes.
Yes, sir. So, viewers, just I'm presenting the PPT on this topic. Yes, sir. Now you can start, sir.
Thank you. Dr. Syed, Dr. Rajesh Singh, all members of the faculty of the Parallel University Law Department, it's a faculty itself, is it? Law faculty, all students and persons participating in this webinar. My greetings to you on a Saturday morning. That you're keen to attend a lecture on judicial review on a Saturday morning shows that you are interested in the subject. Judicial review is a very peculiar subject which needs a lot of careful attention, because this appears to be some kind of a controversial subject also. Now, what is judicial review? Judicial review basically is a concept by which the law that is made by, originally it used to be made by a sovereign. If you go by Savini's definition of law, law is a command from a sovereign to the subjects, etc., which had to be followed at the cost of its being, flouting it, resulting in some kind of punishment. If that was to be the universally accepted principle, then there would be no difficulty at all. You would have had monarchs all over the world. But somehow, civilized societies thought that there should be some check on this kind of powers exercised even by sovereigns. So, judicial review is a concept that has evolved very late in England and somewhat improved upon by the famous judgment of John Marshall in United States and by a series of judgments in Canada. But let me tell you something that probably is not captured in the PPT itself. That this is a concept that has been there in India from the time of the Upanishads. In the Brihadaranyaka Upanishad, there is a very famous saying, Kshatrasya kshatram yad dharmaha. So he says, the Upanishad says that Kshatra is the person who is enforcing the law, the Kshatriya. They say the dharma, the concept of dharma was that dharma is something superior even to the Raja. So the Raja also has to obey it. Therefore, if the Raja makes a mistake, there must be somebody to point out and say, hey, this is where you are wrong, what you are doing is not correct, therefore retrace your steps. That is really the concept of dharmic review, which we call by the very facetious expression judicial review today. There is a very famous story in Mahabharata where a king known by his name was Vena. He was anointed as the king. At the end of which he got so happy and said, I am the Raja, I am the Raja. Adandyoham, Adandyoham. He says, nobody can question me and nobody can question me. The Raj Purohit who is sitting next to him cautioned him, says, Dharma Dandyosi, Dharma Dandyosi. So you are answerable to the Dharma, you are answerable to Dharma. So this concept that there is a principle higher than the person enforcing the law has been there from time immemorial in all the civilizations. In the Islamic countries also it is also there. In the Jewish countries it is there. I need not go into all that because it will take me another whole day to talk about all that. Finally, what is this review? So it is the power of some independent entity, let's call it for the time being the court, to consider the validity of acts and other organs of the government where the issue of constitutionality is germane to the disposition of lawsuits properly pending before the courts. Now, as I told you, this concept of judicial review has different shades of meanings and connotations under different civilizations. I even go, although I have said democratic constitutions, civilizations itself considered it. And now, if you remember way back in the biblical story also, when Moses came down from the what is that Sinai hill where he had gone, he brought the tablet with him with the 10 Commandments. He threw it at the people below and said, "Those who do not respect this law shall die by this law," which he thought was superior to the law that was being enforced by the other people that were there, the non-Christians. Now, let's now not go back so much back in law, otherwise we'll all get lost in ancient history. In UK, this was started off as a very different type of institution. If you all remember, even in the British history, the king was considered sovereign, and the atrocities of the sovereign became so much that ultimately it led to a revolution by the people, which finally resulted in the Magna Carta being signed. One of the fundamental principles of the Magna Carta was that the parliament would be supreme. You know why? Because the parliament is dominated by the people elected, the demos. So democracy, well, that is how it was, the voice of democracy was given the ultimate authority even in England. But the interesting thing in English law is, right from the time of Lord Coke, they assume that all human laws are subject to this concept of natural law, or what what Savigny called the law, the lex, ethos lex naturalis. The natural law is supposed to be by the Greeks, natural God-given law, and therefore all human law was subject to it. Therefore, this concept of all human thinking, all human laws were subject to some overriding fundamental principles was there very much, even in England, even though Parliament was declared supreme, and no less an authority than Professor Dicey in his classical book says that British Parliament is supreme, it can do, undo anything. And he said one time, Dicey is supposed to have said that the British Parliament is so supreme that it can turn, it can do anything other than turn a man into a woman. So Ivor Jennings retorted and said, sorry, it can even turn a man into a woman. How? If tomorrow Parliament passes a law and says, Mr. X shall henceforth for the legal purposes be known as Miss X, that will be the law in the country, nobody can challenge it. That was the power that was accorded to Parliament in the UK. But they always thought that the common law had an inbuilt sense of moral principles, and where the law was absurd, irrational, or immoral, the courts were obliged to declare that the effect of the law would not affect the citizens. This they traced way back to the Magna Carta itself, and said, hey, this is our duty, notwithstanding all the laws made, to ensure that what is considered as the supreme moral principle shall always continue with this country. And this was also the result of the long clash between the clergy and kings, both in Europe and in UK. Finally, the English common law courts always accorded to themselves this right, which slowly distilled itself subsequently into only saying, we are judges appointed by His Majesty. Therefore, we do not go around saying that His Majesty's laws are wrong. But His Majesty has given the authority to others, like the King in Council, to make rules, and we shall examine whether those rules are properly framed or not. So they accorded to themselves only a limited jurisdiction of pronouncing on the validity of the subordinate legislation. The Americans are, of course, revolutionaries. The Americans threw off the British principles. Even they said, we don't want the famous Boston Tea Party. You're all aware of that. After the War of Independence, the Americans had their own way of looking at things. And in this famous case of Marbury versus Madison, where a question had arisen whether the state could enforce some law and a court could declare on the validity of the law. Chief Justice John Marshall, he had a very great man in the human legal history. He said that the Constitution of the United States confirms the principle, which is essential in all written constitutions, that any law which is repugnant to the Constitution is void, and that the courts as well as other departments are bound by the Constitution and not by the void laws. Next, please. Now, this was accepted in a series of judgments. There is not much time now to go into all that. I'm sure Professor Rajesh will teach you all this. There are a series of Canadian Chief Justices who have followed this law and pronounced on this in various judgments. Then the basis on which the learned Chief Justice John Marshall founded the doctrine of judicial review of laws was the following. The Constitution is the fundamental and paramount law of the nation, and therefore it has to command supremacy. In the case of written constitutions, since there is a federal hierarchy of the states, the court has to confirm the dual function of maintaining the balance between the federal courts. Otherwise, there will be infinite chaos. Therefore, that is one reason. The other reason, of course, is that all power, judicial power in the United States is in the courts, and therefore the courts ultimately must take a call on the validity of the validity of the laws passed either by the federal parliament, federal Congress, or by state legislatures, and see how far they're in conformity with the American written Constitution. Next, please. Now we come down to our own country. We got our Constitution into force from 26th of January 1990. Prior to that, we had the Government of India Acts of various vintage, the last one being Government of India Act of 1936, I believe. Now, even in the Government of India Acts, there was this kind of a provision that if there was something that was enacted by a state legislature which was given limited jurisdiction under the Government of India Act, and there was inconsistency between the central legislation and the provincial legislation, which would prevail was an issue that had to be decided, and the courts were given the power to do this. Now, this continued and spilled over when the Constitution was enacted in 1950, and the Constitution made it explicit. Article 13 said, anything that is inconsistent with the principles of fundamental rights in Article 19, in chapter part 3 of the Constitution, would be void for inconsistency, and whether it was a law that was already existing or a law that is made subsequent to the coming into force of the Constitution, it would be void, and the courts were given, the Supreme Court particularly, had this power under Article 32 of declaring it to be invalid and opposed to the Constitution. Now, this power is also vested under Article 226 with the High Courts, which also have this power apart from the other power of issuing different kinds of orders. Now, in A.K. Gopalan's case, way back, the Chief Justice pointed out that Article 13 has been inserted in Part 3 for a good reason, namely that Article 13 is not the thing it's not a fountainhead of the power. The power always existed. See, this is what I'm pointing out to you. The power existed right from the time of the Brihadaranyaka Upanishad. People are giving it different labels and saying, oh, okay, we'll recognize it. Article 13 recognizes what was fundamentally the power that existed in the judicial independent form to declare the validity of the legislation. Now, they also said that between Article 13 and Article 32, the power is not exhausted and that it can even otherwise be exercised by the Supreme Court as long as their job is to act as sentinels qui vive to the Constitution, as the Supreme Court put it. Then, therefore, from A.K. Gopalan's, of course, in A.K. Gopalan, there was a lot of controversy about these police powers, and then we need not go into it. Otherwise, A.K. Gopalan is subject to review of one big lecture itself. Then, what is the judicial review in India? Why is it necessary for the courts to do the judicial review? Please note, first of all, there may be situations where the law passed by the legislatures, either the parliament or the state legislatures, and all subordinated delegated legislation, meaning rules passed by governments, municipal corporations, whoever has got delegated authority, may be inconsistent with the provisions of Part 3 which guarantee fundamental rights. Please note, always wherever there is a clash between a fundamental right and any other piece of legislation, however sacrosanct it may be from Parliament or however inconsequential from the municipal corporation, the fundamental rights always must reign supreme. If the fundamental rights are to be bypassed, if they are to be impinged upon, there is a methodology that is prescribed in Article 2 of Article 19 of the circumstances when these fundamental rights can be surpassed and to what extent and to what purpose only. Beyond that, it is not permissible for anyone to infringe the fundamental rights in any other manner. Now, therefore, in India, basically, the courts, the constitutional court, that is the High Court and Supreme Court, can do what? Can declare a law, whether made by Parliament or any other subordinated delegate legislature, to be invalid for inconsistency with the provisions of Part 3, namely the fundamental rights. They can also examine a situation and say that a law made by the state is inconsistent with the law made by the central government, and therefore it is invalid by reason of Article 256. They can also go into and say whether the law made is made by the competent legislature. Why does the question of competent legislature arise? The Parliament has divided all legislative subjects into three compartments. The one is reserved for Parliament, known as the Union list. One is reserved for the list, known as state list. And one is a list where both can operate simultaneously, known as the concurrent list. Now, whether the legislature has exceeded its legislative competence is an issue that is to be decided by the constitutional courts. Then we come to the other issue. This would have been the exhaustive list of the court's powers earlier. But after the judgment in Keshavananda Bharati, one more ground has been added. What is that one more ground is interesting. Now, Keshavananda Bharati gave rise to a very peculiar situation. Fundamental rights are a part of the Constitution. Article 368 of the Constitution gives Parliament the power to amend the Constitution. Of course, by following a certain procedure prescribed therein. The question arises, India is a democratic country. Let us say Parliament by the appropriate majority or even unanimously decides tomorrow and say, no, we don't like democracy, we want it to be a monocracy. Now only the Mr. So-and-so will be the permanent president of this country as long as he lives. Let's say it's passed by Parliament unanimously. Then are we bound to accept it? For first time, Keshavananda Bharati said, no, there is what is known as the basic feature of the Constitution, which even by unanimous amendment passed by the Parliament cannot be taken away. So therefore, this concept of basic feature of the Constitution was evolved for the first time. Actually, it had earlier surfaced as a minority vote, minority opinion, and was picked up by the majority in Keshavananda Bharati and became the law of this country. As a consequence, and not only that, as a consequence of this, today a fourth ground of attack to legislation is this infringing the basic structure of the Constitution? If all of you remember what happened to the NJAC Act, the National Judicial Appointment Commission, it was struck down on this ground only, that it was opposed to the basic structure. They have said the basic structure is judiciary is independent. Judicial independence is the basic structure of the Constitution. Therefore, anything that infringes it, never mind how you come to bring it about, is bad. It has to be invalid. And then the question is the fundamental nature of the Indian democracy, the polity of Indian democracy. Can it be changed into a monocracy? Can it be changed into a sovereignty? Can it be changed into something else? No, it cannot be, because that would be affecting the basic structure, and therefore the courts are competent to strike down such an amendment. Now, who has to exercise this power is not very clearly laid out, but I assume that whoever is the authority entitled to and empowered under the Constitution can be able to exercise it, whether it is under Article 32 or under Article 26. Next, please. Now comes another interesting facet of the development. Article 32(3) provides that the Supreme Court, without prejudice to the clauses of Articles 1 and 2 of 32, Parliament may by law empower any other court to exercise within the local limits of jurisdiction all or any of the power exercised by the Supreme Court under Article 2. Therefore, strictly speaking, if Parliament were to pass a law tomorrow that the district court will be empowered to issue writs, which the Supreme Court can do under Article 32, a $1 million debate will arise as to whether it is constitutionally valid or not. Now, I'm not going to hazard an opinion on that. I will leave it for you people to consider it and debate it. Not only that, I go one step ahead. Parliament may tomorrow, by following this, may say, I'm going to give the same power to the jurisdictional, what do you call them, JMFC or the junior magistrate or somebody in the taluka. The lowest civil court will exercise this power. Can you say it's constitutional, unconstitutional? Is a $1 million debate which nobody has explored. And I'm sure someday something will happen and the law will get settled on that. But what is interesting is that, nextly, following up on this, the Parliament was emboldened to add 2 constitutional amendments by which they wanted to increase tribunals in the country and invest them with this kind of a power. Now, you have these 2 Kumar judgments, Sampath Kumar to Chandra Kumar. What started off in Sampath Kumar? In Sampath Kumar, Justice Bhagwati went overboard and said, hey, Parliament has a full... But I don't know whether a tribunal can be called a court as such, although it may have its full trappings. So I'm myself not very sure whether the judgment in Sampath Kumar was right, because Sampath Kumar upheld 322A, 322B on the ground. Hey, Parliament is empowered to invest this constitutional function, constitutional jurisdiction in any other court, and these are courts. Are they courts? Is a $1 billion question which nobody really raised. Somebody should have raised it. Anyway, it's not necessary to raise it now, because after a decade of these tribunals under 320, first of all, they started with the central administrative tribunal and the state administrative tribunal, and then they went on adding more and more tribunals, and it went to such an absurd limit. I remember when I was a judge of the Bombay High Court, and I was sitting heading a bench, one member of the administrative tribunal had filed a writ petition saying that High Court judges have this facility of going in red dome. In those days, we had this facility of a red dome on the car, and they get so much salary that I exercise the same powers with High Court, and therefore I should be entitled to it. He said, sorry, we don't know whether you have the same power or not, so we are not entitled to it. You are not a judge of the High Court. That is definite. Apart from that, they also started claiming that they were empowered to exercise powers under Article 14, which is again a $1 million question. Fortunately, all that got resolved by the next judgment in Chandra Kumar. After having, can you go to the next slide, please? After having reviewed the working of the tribunals for a decade or so, in Chandra Kumar, the judgment is very specific and says the power of judicial review over legislative actions is under 226 and 32, and the essential and they, for one good thing is they said that this is also a basic feature of the Constitution. So luckily for us, no parliament in this country can ever say we are abolishing. This is the result of what happened during the emergency. So they cannot say, if you remember what happened in emergency was the power to move the High Court and the Supreme Court under Article 226 High Court, 232 Supreme Court was itself suspended. And there is, of course, a famous statement said to have been made by the then Attorney General that during the emergency operation, when there is a suspension of the fundamental rights, a person can be shot dead and nobody can ask any questions. Now, whether such a statement was apocryphal statements was made or not is a question It's not there anywhere on the official record, but the lawyers who appeared in the courts have told us this. Then, therefore, two things arise from Chandra Kumar. One is, it's an essential feature of the basic structure of our constitution to judicial review. Number two, both the High Court and the Supreme Court have this power and nobody can take it away from them because it's a basic structure. And the third is, the Constitution says the superintendents of all the subordinate courts within the state will rest with the jurisdictional High Court under Article 227. That also they say is a fundamental feature, basic feature of the Constitution. Nobody can take it away. This was the reason was that during the emergency they were trying to take away all the powers of the High Court and denude the High Court of its real glorious powers that it had. Next, please. So after Chandra Kumar, what now? So in this long history of the judicial review, today we are left with a situation where the power of judicial review is being used both by High Court and the Supreme Court. Now, simultaneously with the power of review, I must also point out that original classic theory of locus standi, namely a person who can come to a court and ask for relief only if he is aggrieved, was bypassed way back by Justice Bhagwati inventing this PI, that is public interest litigation. Public interest litigation means what? That why was this whole concept of PIL developed? In order to exercise my rights and seek relief from a forum, it is necessary that I must be educated enough to know what is my right, which is the law under which I can claim it, which is the forum where I can claim it. Now, in this country, thanks to the widespread ignorance, widespread lack of education, widespread poverty, people are disempowered. They do not have a concept of their fundamental rights. They do not have a concept of their even ordinary legislative rights. So, in the absence of good knowledge, in the absence of good access to courts, they were not able to access. Therefore, the PIL was invented, saying that if there is a class of persons who are disabled on account of various circumstances and unable to seek relief, some public-spirited citizen might come forward and put their grievance before the court, and the court is satisfied, the court will grant relief to the persons who are aggrieved. This all started in the Bandhuva Mukti case, thanks to Justice Bhagwati. Now, that was not intended to be a general blank check to everybody. Now what has happened is, today PILs are filed in the Supreme Court and in the High Court, raising all kinds of unimaginable questions of law, unimaginable situations where persons who have nothing to do will be asking relief. So I remember once I described PIL as it was originally public interest litigation. Today it is either profit interested litigation or persecution interested litigation or publicity interested litigation. This is what it has degenerated into. But remember, even in a PIL, it is possible to do judicial review. The PIL will say, well, let's say that the group of citizens is disempowered, as a result of which some social activist organization comes and points out to me that their fundamental rights are being breached. It is open to the court, the High Court as well as the Supreme Court, to grant appropriate relief to the persons who are actually affected, the persons whose fundamental rights are being infringed. Therefore, this is one powerful, but at that time, we are not going to ask a question and say, hey, are you afraid? The man who comes before me is not at all affected. He may be a social activist. This is precisely what is happening in the Supreme Court. Every day you will find hundreds of petitions filed. Some of them are genuine, some of them are bogus. Now, PIL is being used as I say, a shoulder for someone. If there is already a factory running and someone wants to start another factory, the first factory fellow will say it's a competition to me, so he'll come up with some PIL. The PIL will say what? There is a violation of the Environmental Protection Act. And the Environmental Protection Authority is not taking appropriate action. Therefore, PIL to enforce the provisions of the Air Act, of the Pollution Act, whatever it is. Or the revenue authorities are not demarcating the boundary. The revenue authorities are allowing, not following the zoning law. All these are possible subjects in a PIL. And if that happens, the courts have to be very careful, look at it and go back to the situation and see whether the PIL is really a PIL which was intended to be way back by Justice Bhagwati, or is it just masquerading as a PIL, but it's actually a private interest litigation. So the judicial review is a strong power, but exercising that power requires balancing of various aspects. The power of the central government, as again the state government, the question of examining the competence of the legislature, examining the competence, the competition between two competent legislatures, and in a situation that is covered by the concurrent list, the question of whether Parliament has already occupied the law, the field, legal field, so that there is no scope for state legislation. These are the finer aspects of judicial review, and as long as the courts are functioning, and I hope they will continue to function for a long time also, we can say that we are safe in their hands, and whether we are prisoners without bail or persons arrested without authority of law, we only have the courts to look forward to, and hopefully they'll continue to give us relief that is required under the Constitution. Thank you very much. It was nice talking to you.
Yes, sir. It was a very fantastic session by you, sir. You have elaborated all the case law, Kesav Nanda Bharti, Minerva Mills, and then you have also elaborated Sampath Rao and Chandra Kumar. With all the various case law, you have elaborated in a very systematic way, sir. My student have a great privilege to listen to you, sir. Sir, my students, some of the LLM students have put certain questions on my WhatsApp, sir. So I'm putting to you, sir. There are 3 questions.
Yeah.
Sir, first question is, why review are disposed wide circulation without listening and hearing in the open court in the Supreme Court?
Okay. There is no law which says that the review has to be heard in court or has to be disposed of without hearing. There are occasions, see, most of the reviews are meaningless reviews. Honestly, I'm telling you, I've sat on the Supreme Court bench. But most of the time, it's taken as a next round of appeal. What do they do? Go to the court, High Court. No, let's start with the lower court. From the lower court to the High Court. Lose 136 appeal, which is really a discretionary appeal. Fails. Then what do? Ask for review. Fails. Then what do? You go by a curative petition. This has become the unfortunate trend. Therefore, a review is, what is review? The Civil Procedure Code has definite grounds. Review is not permissible on the ground that the judge made a mistake. No. That there was some evidence which was available, which could have been brought to the notice of the court, and which you ought to have known, you did not, it was not brought to the court. Or that evidence has become available only after the judgment is delivered. These kind of fundamental mistakes have to be shown. If it is not there, the same grounds which were urged in the SLP are urged and then said, I am asking for review. It's just sheer waste of time. As it is, the judges don't have time to even read paper there. Forget about hearing in court. Therefore, we have said, if that is there, we'll circulate it. If there is nothing, we'll dismiss it. But let me tell you, on occasions where it is demanded, I have insisted on court hearing, and I even reversed the judgment on which the review was that. It all depends on case to case. There is no hard and fast rule on that.
Sir, one more question from one of the LLM students, sir. His question is that any instances where the reviews have been allowed while being judged by other judges than the judge who passed the impugned order?
Yes, I have done it myself. See, normally, review is all under the Civil Procedure Code. The review always goes to the same judge or the same bench. But it might happen between the date of the judgment and the date of the review petition coming up for hearing. Some judge might have retired. If it is a single judge, he must have retired or died. Or a division bench composition might have changed. In which case it is heard by a subsequent judge. In fact, I have myself, in 2 or 3 matters, I have allowed the review because I thought if justice required that it had to be reviewed.
Sir, one last question, sir. One of the more LLM student. Sir,
And
he
one second, Rajay.
yes, sir.
The review judgment being allowed is a reported judgment. I don't remember it now at this point of time. Please
Okay.
find out.
Oh, yes, sir. I will find out, sir.
Find out by searching on my name. You will find it.
Yes, sir. Yes, sir. Sir, one more question, sir. What are the key issue for litigators considering the judicial review proceeding?
What's the key issue? I don't follow the question. What is being said?
Sir, actually, his question is that what are the factors for the litigator?
I told you, open the civil procedure code.
Yes, sir. Yes, sir.
There is a section which deals with review. What
Yes,
are
sir.
the grounds?
Yes,
You
sir.
must demonstrate those grounds.
Yes, sir. Yes, sir.
Because the Supreme Court is not supreme in the sense that it can do anything. I don't believe that.
Yes, sir. Yes.
Although some of the judges believe it, I did not and I will not accept
Yes, sir.
that theory. Supreme Court is also bound by the law of the country. And
Yes.
first of all, let's put it in proper order. Bound
Yes.
by the Constitution. And what is the oath of office of the judge? That I shall abide by the Constitution and the laws made and validly made under the Constitution. So I have to look at the Constitution, valid law, then I have to go by the law. Civil procedure is such a valid law,
Yes,
it
sir.
has to apply. Civil procedure has defined grounds on which review is permissible. Same thing with the Supreme Court. That's all.
Sir, it was a very fantastic session, sir. And my students are getting more messages that it was a very fantastic session by you, sir. So, sir, on this platform, certain few questions that I will mail you, sir. If any student, some PhD students have told that they want to ask some other questions, so I will put you on the mail, sir. So, on this note, sir, I am thankful to you from the Parul Institute of Law on the behalf of Parul Institute of Law, Parul Institute, sir, on this platform. And this is the live, so my student who have just missed, and even the advocates from High Courts and Supreme Court are also seeing this webinar, sir, because I have circulated. So it is a great fruitful session to all the viewers, sir. So on this behalf,
One question I want to ask you. Where
Yes.
is the university situated?
sir, pardon, sir.
Where is the university situated?
Sir, it is at Vadodara, sir.
Oh, in Gujarat. I thought
Yes,
it was in Rajasthan somewhere.
No, sir. It is in Gujarat, sir, and it is a really very upcoming university and renowned university, sir. I think you have seen the ads on TV also, sir.
The only
sir.
university which I visited in Gujarat is Nirma. 2-3 times I have gone to Nirma.
Yeah, I know, sir. I have seen your lecture on Nirma, sir. That I have seen. So, sir, it is a great pleasure, sir, that we will also like to invite you when this pandemic will over at our university, sir. So, thanks a lot for this live coverage. And I am also thankful to Jiten Kubhani, who has continuously giving our live coverage from our Parul University. Mr. Jiten Kubhani, sir, I am also thankful to you, sir. So, on this note, sir, I am closing this session, and I am getting a permission to close this session.
Namaskar.
Thank you, sir.
Yes, all of you keep safe, keep healthy. That's
Yes, sir. Thanks a lot, sir. Thanks a lot, sir.
Bye.
Bye, sir. Bye, sir.